Hey everybody, how's it going? Welcome back to Copper Jacket TV. So I think this is going to be the end of mag bans nationwide. No more capacity limitations, no more arbitrary 10 rounds. I think this case right here is going to end it all. So today we're going to be talking about a brand new case that was just petitioned to the Supreme Court called Hanson v. District of Columbia. This is a big one. You guys need to hear about it. So let's get to it. Now, real quick before we get started, if you're watching this video and you have not yet subscribed, consider hitting that subscribe button. It's free, it only takes a second, but it really does help us out here quite a bit. It helps us spread our message, and it lets the powers that be know that you guys want to see content like this. So with that being said, let's get to it. Okay, so let's go ahead and talk about what's going on with Hanson v. District of Columbia and why I am so excited about this case. Now, when I say this is a new case, this is not a new case. This case has been going on for quite some time, but it's new to the Supreme Court. As a matter of fact, they just petitioned for writ of certiorari to the Supreme Court back on February 26th. So with that being said, let's go ahead and talk about why I'm so excited about Hanson v. District of Columbia. This case is different than any case that I've seen hit the Supreme Court as of yet. Even Ocean State Tactical v. Rhode Island, which is another magazine ban case that's currently sitting before the Supreme Court that has received multiple conferences and been pushed off multiple times, and if you ask me, doesn't really have a great chance of being accepted by the Supreme Court. I really hope it does, but I'm just not too sure about it. This particular case is ripe for the Supreme Court. It is absolutely perfect. Now again, this is another case that deals with that whole stupid 10-round magazine capacity limitation. Somebody somewhere came up with this 10-round capacity thing, and then it just seemed to stick, and other states started to adopt it. For some reason, if you put that one extra round in there, it becomes against the law in these blue states. And it's absolutely ridiculous. It basically puts a ban on commonly owned and commonly possessed magazines across this country. Things that are in common use for lawful purposes, which are protected by the Second Amendment. So again, it's another 10-round magazine capacity ban that we're dealing with at the Supreme Court. But this case is a little bit different because the D.C. Circuit Court of Appeals that recently gave their opinion in this case actually admitted that magazines that can hold more than 10 rounds are in common use for lawful purposes. Now, that should be the end of it, right? It should be all over. The Supreme Court said if they are in common use for lawful purposes, then they are protected by the Second Amendment and they cannot be banned. But guess what? The Circuit Court didn't care. Even though they admitted that they're in common use for lawful purposes, they said that they are still dangerous. And so apparently, because they are dangerous, even though they're in common use, they decided to use the historical analog of regulations that were given to Bowie knives to justify the existing law that stands in DC today. So they're saying because they are dangerous, like Bowie knives, even though they're in common use for lawful purposes, we could still allow DC to ban them, which just goes against just about every Supreme Court precedent in this current area. So Hanson decided to appeal to the Supreme Court, and that's what happened back on February 26th, and they said this. So here's a look at the petition for writ of certiorari to the Supreme Court in Hanson v. District of Columbia. So here are the questions that are being presented to the Supreme Court. Question presented. This court in District of Columbia v. Heller found it fairly supported by this historical tradition of prohibiting the carrying of dangerous and unusual weapons that the Second Amendment protects the possession and use of weapons that are, quote, in common use at the time, NYSRPA. In this case, a divided DC panel held that magazines capable of holding more than 10 rounds of ammunition are arms, quote, in common use for lawful purposes, but it nonetheless concluded that the district may categorically ban them because they are particularly dangerous, analogous to Bowie knives and fully automatic machine guns. Accordingly, the question presented is whether the Second Amendment to the United States Constitution allows a categorical ban on arms that are indisputably common throughout the United States and overwhelmingly used for lawful purposes generally and self-defense specifically. Now, they continue to say in their petition, this court's decision in Heller, reaffirmed by Bruin, held that the Second Amendment protects arms in common use for lawful purposes. But in direct contravention of Heller, some circuits, including the court below, hold that arms in common use for lawful purposes may be categorically banned based on a court's subjective view of their dangerousness. This issue, which affects millions of Americans' constitutional rights and a wide variety of arms, will continue to arise until this court settles it. It is undisputed that Americans possess hundreds of millions of magazines that can hold more than 10 rounds of ammunition. Indeed, magazines that can hold more than 10 rounds of ammunition come standard with 4 of the 5 best-selling self-defense pistols. These standard capacity magazines are the exact type of magazines that the District of Columbia categorically banned on pain of a felony conviction. The D.C. court acknowledged that these magazines are ubiquitous and overwhelmingly used for self-defense, yet it considered them so particularly dangerous that the Second Amendment allows the district to prevent everyone from possessing them anywhere, including in the home, and for any reason, including for self-defense. At the bottom, the D.C. Circuit's opinion devolves into an interest-balancing exercise. In its view, standard capacity magazines are too particularly dangerous to be trusted in the hands of Americans, so the district can ban them even though they are undisputedly in common use for lawful purposes, and indeed it is estimated that there are enough in circulation to provide at least one to every man, woman, and child in America, because this conclusion, adopted by other circuits, directly contradicts Heller and Bruin. This court's intervention is necessary to protect the fundamental rights of millions of Americans. So it's the D.C. Circuit Court of Appeals that actually stepped on this one, because by admitting they're in common use for lawful purposes, but allowing them to be banned anyway, they have basically made this the perfect case for the Supreme Court. And if the Supreme Court takes this case, I am fairly certain that they are going to overturn the ban. And if they do that and say that it's unconstitutional to ban these arms in common use for lawful purposes, then all bans across the country are going to be done. It doesn't matter what state you live in or what capacity the ban has become, it's going to be unconstitutional to do so. So this could end up overturning all of the bans across the country and everywhere. I think they have a very strong fight here, especially with so many dissents in their favor from the D.C. Court of Appeals. So just to summarize here, we now have a case as of February 26th that is sitting before the United States Supreme Court that could overturn mag bans, thanks to the fact that D.C. admitted that they are in common use for lawful purposes. This is, again, a case that is ripe for the Supreme Court to take. It is absolutely perfect, and there is no reason why the Supreme Court shouldn't take this case and finally put this question to rest. I know the Supreme Court has been absolutely terrible at taking cases like this, but even the political winds are blowing in the right direction here, and so they need to do something about this and finally answer the question so that they can stop all of these constitutional infringements that are happening in all of these different blue states. This needs to be put to rest. So I am really excited about Hanson v. District of Columbia. I think this is a great case, and I'm going to be looking forward to seeing what happens. First thing we're going to do is wait for DC's response. Again, DC's response is due by March 31st. And then after that, we'll see what the court decides to do with it. It'll be conferenced, and then we'll see what happens after that conference. So I will keep you guys updated on this one. I'm going to be watching it very, very closely. I think we actually have a really good chance here. But anyway, I wanted to let you guys know about that. I want to thank you all very much for watching. I really do appreciate it. If you haven't done so already, consider hitting that subscribe button. The like button is always appreciated. Leave your comments down below if you guys have an opinion, and have a great day.